coverage of the Watergate hearings conducted by the Senate's Select Committee on Presidential Campaign Activities. Here are CBS News correspondents George Herman and Nelson Benton.
Good morning. The Senate Watergate Committee, or as it calls itself, the Select Committee on Election Procedures, is beginning a new technique of hearings 5 days a week. In the past, they've had hearings only Tuesday through Thursday. Now they're commencing a series of, at least this week, they're going to hear 5 days a week. And the committee has been meeting in executive session to discuss the subject, we understand, of whether they will continue to meet 5 days a week. The witness this morning, Nelson Benton, is John Dean.
It is John Dean. His testimony, George, was postponed for 1 week in deference to the Nixon-Brezhnev summit, which took place all of last week. Originally scheduled to begin last Tuesday, now scheduled to begin today. That postponement took place as a result of a 6-to-1 vote by the Watergate Committee. Senator Lowell Weicker, the Republican from Connecticut, the only one who voted against the postponement. And so today, Mr. Dean, the 34-year-old former counsel,
now being busily photographed.
Now being busily photographed in the caucus room, is to testify. We understand, George, that Mr. Dean has a prepared statement of perhaps 150 pages, and it's possible that that could take most of today.
All right, and while we're looking at John Dean, let's go talk to Dan Shore, who's outside the committee room. Dan?
Yes, George. While you're looking at John Dean, I'm holding here the first 98 pages of what's expected to be 140 pages of testimony that Mr. Dean will be delivering today. This is the first installment of the document. I've been going through the first part of it rather rapidly. There are no major surprises in it, although it outlines in some detail. It outlines in a great deal of detail the president's concern about demonstrations, the fact that the president, according to Dean, on one occasion asked to have an unruly person in Lafayette Park physically removed, and that somebody said use thugs if necessary. But let me first tell you the decisions of the executive session of the committee this morning. First of all, the 5-day-a-week sessions now will become the standard order of things. After this week, there'll be a week of recess, following which they'll be back on a 5-day-a-week schedule until August 3rd, by which Senator Baker tells us they hope to complete at least the Watergate phase of their investigation, with other phases to follow after the congressional recess. It has also been decided that John Mitchell, the former Attorney General and former campaign manager, who was asked not to appear now, is to appear now. That is to say, on Thursday, if John Dean completes his testimony by then, he is to be the next witness, unless, as Senator Talmadge told us, something happens in Dean's testimony that would require calling another witness briefly. The other decisions that were made had to do with some of the documents that had been put in the safe deposit box by John Dean, turned over to the committee, to the courts, and to the prosecution. Most of those documents are to be made public. A few of them on what could be considered really national security grounds after consultation with security agencies may not be made public. Let me throw it back to you for a moment.
Thank you, Dan Shore. Our coverage of the Watergate hearings live from Washington will continue in a moment.
I'm sand. I'm wheat. The colors of Clairol's naturally blonde are the blonde colors found in nature.
I'm moonlight. I'm sunlight.
18 shades of soft, gentle color. Just about the most natural shades on earth to shampoo in after lightening your hair. The beautiful thing about naturally blonde is that that's exactly what it is.
How'd you like to be a daffodil?
Wouldn't it be wonderful if your husband shined your whole house while you slept? It could happen with Windex. Windex with ammonia D. It gets windows sparkling clean. Chrome, tile, stainless steel, everything sparkling bright with a spray and a wipe. And Windex even helps fight steam buildup on bathroom mirrors. Windex does it all. So wake up to the sun. Let it shine on you.
I love wood furniture. That's why I've designed and built furniture like this most of my life. This crib I made for my daughter when she was born. You know, the furniture I built, I always gave it rubbed-in paste wax beauty. But Johnson Wax showed me how to get paste wax beauty instantly with new Pledge. This table was rubbed with paste wax for 12 minutes and a lot of muscle. Now I'll dust this one with new Pledge. You know, Pledge now has an enriched formula containing key ingredients found in Johnson paste wax. To me, it's a dead ringer for the paste wax shine. So, for the rubbed-in beauty of paste wax instantly, dust with new pledge.
Okay, that covers that. And we'll put this over here. And anyway, once the party gets going, no one will notice the rug.
Fred, we need the glory.
With Glory Rug Shampoo, you can clean your whole rug this afternoon. Entertain guests tonight.
We're looking now at a packed caucus room in the Russell office building where the audience and we are awaiting the testimony of John W. Dean III, the former counsel to the president, due to testify this morning as the Watergate hearings resume after a week's delay for the Nixon-Brezhnev summit. George, we might talk while we're waiting for the committee to resume about the great number of leaks that took place during that hiatus for the summit.
Well, let's first remember that the hiatus was requested by the leadership of the Senate, by Senator Scott and Senator Mansfield. But during that period, it started, it seems, with a series of leaks about John Dean from White House friends, the friends of the president, seeking to discredit him. And it reminds me that in Six Crises, Mr. Nixon's own book, and he talks about the Alger Hiss case, he says that the delay in the hearings was of benefit only to those people who were telling untruths, giving them a chance to build up their case. So in any case, the leaks were then followed by leaks from friends of John Dean, and between the two sides, we seem to have gotten an awful lot of what John Dean is going to say today.
Now, those leaks starting specifically with the story that John Dean had used nearly $5,000 of Republican campaign funds to finance a honeymoon back in October. Then that was countered by a leak of the first 2 pages of a summary of his testimony, which was given to the staff of the committee. Then there was another leak of White House accounts of Dean's meetings with the president. This, however, was leaked, we were told, from the committee itself. The White House had provided the committee with that summary. Then 5 more pages of John Dean's summary of his testimony was leaked. And so it has gone through the week. It was characterized by Senator Howard Baker, the vice chairman of the committee, as an avalanche. Another senator called it a hemorrhage. In any event, there seems to be a lot of blood on the floor.
And there's been some argument as to whether the Senate can keep any secrets. I mentioned before that the first leaks which came out were of benefit to those who were supporting the president and who were opposing John Dean's attempts, presumably, to cast some doubt on his innocence in this. And I'll just remind you that Senator Hugh Scott, who is President Nixon's Republican leader on the floor of the Senate, took the first available opportunity to refer to John Dean as an embezzler because he had borrowed those $4,800 for his honeymoon, putting in an IOU, and eventually, at least, paying the money back.
I think much of what comes from Dean during his testimony is just how credible he is, and much of what has gone on during this week seems to have been aimed at his credibility or aimed to support his credibility. One senator has said that when witnesses get on the stand before this committee, it becomes very apparent who is leveling with the committee and who's not. Dan Shore, do you have any thoughts on credibility?
Thoughts on credibility? The credibility of this witness today is going to have to stand on his statement. What I will say is that everything so far known of what John Dean has reported has turned out to be correct, if that is a measure of credibility so far. It was John Dean who first blew the whistle on the break-in into the office of the psychiatrist, Dr. Daniel Ellsberg. It was John Dean who said he had had 35 or 40 talks with the president in February and March, with the White House first denied and then was obliged to confirm. I don't want to speak on credibility, which I think is a somewhat subjective matter. What I will say is that Senator Baker and others on the committee have said that everything they have yet been able to test of what John Dean has said has turned out, so far at least, to be correct, which is perhaps a limited way of talking about credibility. What I can say about this is that, having gone now through quickly these first 98 pages, is that it is going to emerge that Dean is about to give as much clearance as he can to his old boss at the Justice Department, John Mitchell, by indicating that Mitchell was a most reluctant participant in the Watergate bugging plan, and that the real pressure came from the White House. But I see now that Senator Ervin is coming into the room, and before the gavel goes, let me return it to you.
Thank you, Dan. And there comes Senator Ervin carrying his gavel in his hand along with his notes, followed by members of his staff. And in just a moment, undoubtedly, we'll hear the senator bang the gavel, and then if he follows his usual procedure, he will announce what took place in the executive meeting before this public meeting of the Select Committee. And Senator Ervin usually takes the time, perhaps 10, 15 minutes, to explain all the decisions that were arrived at and sometimes the reasons why those decisions were made. There goes the gavel. Let's join the committee.
The committee will come to order. Council will call the first witness.
Mr. John W. Dean III.
Stand up and raise your right hand. Do you swear that the evidence that you shall give to the Senate Select Committee on Presidential Campaign Activities shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, so help me God.
Now, you are accompanied by counsel, and I would ask, your name is John W. Dean III.
That is correct.
I would ask counsel to identify themselves for the record. You may be seated.
Mr. Chairman, my name is Charles N. Schaffer. I'm from Rockville, Maryland. I'm one of Mr. Dean's counsel.
Mr. Chairman, I am Robert C. McCandless of Washington, D.C., and I, too, am one of Mr. Dean's counsels.
I would like for the members of the committee and the witness and counsel for the witness to pay strict attention to what I shall say. Mr. Dean appears before the committee and has appeared previously before the staff of the committee in obedience to subpoena from the committee. Mr. Dean at all times has claimed that he is privileged against testifying by the self-incrimination clause of the Fifth Amendment on the ground that any testimony he might give to the committee concerning the matters the committee is authorized to investigate might incriminate him. And therefore he appears involuntarily. The committee has unanimously requested, in times past, His Honor Judge John Sirica, Chief Judge of the United States District Court for the District of Columbia, to enter an order of immunity for the witness under the provisions of sections of 6002 and 6005 of the Title 18 United States Code. The committee, pursuant to those statutes, gave 10 days' notice to the Attorney General of his application to Judge Sirica, and at the instance of the Attorney General, Judge Sirica delayed entering an order until more than 20 days thereafter had expired. He then entered an order of immunity under the statutes. And Mr. Dean is now informed of that fact and has previously been informed of that fact, and that he is testifying under this order of immunity granted to instance of the committee. And he appears here involuntarily as a witness pursuant to this order, and he has heretofore been ordered by the committee to answer the questions, and he has all the testimony he's previously given to the committee staff, and all of the testimony which he may give to this committee is given by him on the basis of the order of immunity. Is that correct?
That is correct, Mr. Chairman.
Now, if there's no objection on the part of any member of the committee, the chairman will find his statement to be the facts on behalf of the committee.
Mr. Chairman, I might say, just for the completion of the record in that respect, it's also my understanding that in addition to appearing in response to subpoena, and after having claimed his constitutional privileges, after the attachment of use immunity, as the chairman has just indicated, that counsel for Mr. Dean at a previous executive session of this committee made certain other requests, particularly that the witness waived no rights, that he was appearing involuntarily and pursuant to subpoena, that he filed an application to be excused from testifying because of the fear of prejudicial effect on the possibility of his subsequent trial, and that he requested that coverage of the hearings be either an executive session or limited in accordance with the rules of this committee. I hope it's appropriate to say, Mr. Chairman, that those matters were taken into account by this committee as a whole in executive session, and the requests were denied. I think that the record ought to indicate that further for Mr. Dean's, for the completion of Mr. Dean's situation.
I want to thank you and say I concur in your view.
We appreciate that, Mr. Vice Chairman, and I would like, out of an abundance of caution, so that there be no waiver, for me to again call to the attention of the committee here and now before the public session the content of my letter to the chairman dated June 18, 1973, which I asked you to rule again on the assertions contained therein, and that it be made a part of this public record.
That letter will be printed in the body of the record. I've requested by members of the committee sitting on the left there that you and Mr. Dean swap places because...
I'm going to leave the chair, Mr. Chairman, and sit back.
Because the reporters sort of obstructs their view.
Mr. Chairman.
Mr. Chairman, I'd like for the reporter to move a little back so I can see the witness.
Well, I was going to try to move the witness over here. Yes.
Mr. Chairman, we have one additional matter we'd like to call to the attention of the chair. First of all, the subpoena issued under your rules does subpoena all documents. So we conclude that all materials supplied, other than his oral testimony, all exhibits and other documents are under the same subpoena and must be and are being brought forward in that manner. Also, we bring to your attention again Title 18, the U.S. Code, Section 798, Disclosure of Classified Information, and Section C, saying nothing in this section shall prohibit the furnishing upon lawful demand of information to any regularly constituted committee of the Senate or House of Representatives of the United States of America. We raise that, Mr. Chairman, because, as you are very well aware, and other members of the committee, under a ruling by the Honorable John J. Sirica, this committee came into possession of certain documents which Mr. Schaffer and I, as counsel to Mr. Dean, have not even seen ourselves. They're in your possession. If Mr. Dean is to be asked questions on those documents, he does not have a copy in his possession. The committee would have to furnish such a copy to him for him to be able to refresh his recollection. And we just wanted to make sure that this section of the criminal code and your rules pointed out how they dovetail as to disclosure of secret and classified information.
Well, we will rule on that at the proper time. I'm hoping that I'm expecting rather perhaps questions on those documents which were furnished to the committee by Judge Sirica at the request of the committee. The questions on that will probably not come up today, and we'll handle that in due season.
Thank you very much, Mr. Chairman.
I'd state myself that for my study of the subject, I think that information or material cannot be classified allegedly in the interest of national security unless it should not be disclosed to an unauthorized person because it relates to either to national defense or to our foreign relations with other nations. I'm of the opinion from my study that there is no authority under that statute to classify any matter merely because it relates to domestic intelligence or internal security. That's a matter, though, that the committee will rule on later when if it becomes necessary.
Let me say something.
It's also our understanding, and I hope it's correct, that Any doctrines of executive privilege or attorney-client privilege have already been taken care of by your committee.
Mr. Chairman,
Yes, I think
might I say a word in that respect, and on the point raised by Mr. McCandless, which I think is important to raise in connection with the protection of his client's rights. It is my understanding, and Mr. Dash, the chief counsel for the committee, can correct me if I'm in error. It's my understanding that on last Monday, there was transmitted to the witness with copies to the committee and its staff a letter from Mr. Leonard Garment, the counsel for the White House, or a counsel for the White House, indicating that the White House would not claim executive privilege as to this witness's testimony, nor would it claim the privilege of attorney-client. And as I recall as well, that on matters of the use of documents nominally classified, that they would leave it to the discretion of the committee to decide how that should be handled.
That is correct, Senator Baker. It initially was an oral statement given to me by Mr. Gorman, counsel for the president, and he followed up with a letter to Mr. Dean, copied to our committee, in which he put in writing that he was authorized by the president to do as you just stated.
And the committee in executive session on this past Monday, I believe by unanimous vote, I'm sure by unanimous vote, authorized the chairman to act on behalf of the committee in the matter of the handling of these classified matters. Thank you, sir.
Certainly let the record show, as Mr. McCandless states, that the documents also, any documents that the witness produces are produced in obedience to a subpoena due case taken.
Yes. Mr. Dean, you have a statement you wish to present to the committee?
That's correct, Mr. Dash, but before I commence reading the rather lengthy statement, I would just like to make a couple of comments. First of all, Mr. Chairman, Mr. Vice Chairman, and members of the committee, I sincerely wish I could say it's my pleasure to be here today, but I think you can understand why it's not.
Mr. Dean, could you please take the microphone and put it closer to you so we could all hear it?
Certainly. It's a very difficult thing for me to testify about other people. It's far more easy for me to explain my own involvement in this matter. The fact that I was involved in obstruction of justice, the fact that I assisted another in perjured testimony, the fact that I made personal use of funds that were in my custody. It's far easier to talk about these things myself than to talk about what others did. Some of these people I'll be referring to are friends. Some are men I greatly admire and respect. And particularly with reference to the President of the United States, I'd like to say this. It is my honest belief that while the President was involved, that he did not realize or appreciate at any time the implications of his involvement. And I think that when the facts come out, I hope the President is forgiven. Pursuant to the request of the committee, I will commence with a general description of the atmosphere that existed in the White House prior to June 1972. To one who was in the White House and became somewhat familiar with its inner workings, the Watergate matter was an inevitable outgrowth of a climate of excessive concern over the political impact of demonstrators, excessive concern over leaks, an insatiable appetite for political intelligence, all coupled with a do-it-yourself White House staff, regardless of the law. However, the fact that many of these elements of this climate culminated with the creation of a covert intelligence operation as part of the President's re-election committee was not by conscious design, rather an accident of fate. These, of course, are my conclusions, but I believe they are well-founded in fact. This committee, however, is not interested in my conclusions. Rather, it's interested in the facts as I know them. Rather than my characterizing the climate and attitudes, I shall, as requested, present the facts which themselves evidence some of the precursors of the Watergate incident. It was not until I joined the White House staff in early July of 1970 that I fully realized the strong feelings that the President and his staff had towards anti-war demonstrators
and demonstrators in general. But even before my joining the White House staff, I was partially aware of this presidential concern, and a concern that in turn permeated much of the White House. During my tenure at the Justice Department as an Associate Deputy Attorney General, I was involved in representing the government in discussions with demonstration leaders regarding the terms of demonstration permits for activities in the capital city. While I was not the decision maker in this capacity, I was in close proximity to the decision-making process and thus realized that the White House, principally Mr. Ehrlichman, often made or cleared the final decisions regarding demonstration activity. It was also because of my proximity to those involved with demonstrations at the Department of Justice that I became aware that the White House was continually seeking intelligence information about demonstration leaders and their supporters that would either discredit them personally or indicate that the demonstration was in fact sponsored by some foreign enemy. There were also White House requests for information regarding ties between major political figures, specifically members of the United States Senate, who opposed the president's war policies, and demonstration leaders. I also recall that the information regarding demonstrators, or rather the lack of information showing connections between demonstration leaders and foreign governments or major political figures, was often reported to a disbelieving and complaining White House staff that felt the entire system for gathering such intelligence was worthless. As I shall elaborate shortly, this attitude towards intelligence gathering capabilities of the government regarding demonstrations prevailed through my tenure in the Justice Department and at the White House. And I was hearing complaints from the President personally as late as March 12th of this year. It was when I joined the White House staff in July of 1970 that I became fully aware of the extent of concern at the White House regarding demonstrations and intelligence information relating to demonstrators. It was approximately 1 month after I arrived at the White House that I was informed about a project that had been going on before I arrived to restructure the government's intelligence gathering capacities vis-a-vis demonstrators and domestic radicals. The revised domestic intelligence plan was submitted in a document form to the President for his approval. The committee has in its possession a copy of that document and certain related memoranda pursuant to the order of Judge Sirica. After I was told of the presidentially approved plan that called for bugging, burglarizing, mail covers and the like, I was instructed by Mr. Haldeman to see what I could do to get the plan implemented. I thought the plan was totally uncalled for and unjustified. I talked with Mr. Mitchell about the plan. He said he knew there was great concern or desire at the White House to see that the plan was implemented, but he agreed fully with FBI Director Hoover, who opposed the plan with one exception. Mitchell thought that an interagency evaluation committee might be useful because it was not good to have the FBI standing alone without the information of other intelligence agencies, and the sharing of information is always good and avoids duplication. After my conversation with Mitchell, I wrote a memorandum requesting that the evaluation committee be established and the restraints could be removed later. I told Mr. Haldeman that the only way to proceed was one step at a time, and this could be an important first step. He agreed. The Interagency Evaluation Committee, the IEC as it was referred to, was created, as I recall, in early 1971. I requested Mr. Jack Caulfield, who had been assigned to my office, to serve as the White House liaison to the IEC. And when Mr. Caulfield left the White House, Mr. David Wilson of my staff served as liaison. I'm unaware of the IEC ever having engaged in any illegal activities or assignments, and certainly no such assignment was ever requested by my office. The reports of the IEC, or summaries of the reports, were forwarded to Haldeman and sometimes Ehrlichman. In addition to the intelligence reports from the IEC, my office also received regular intelligence reports regarding demonstrators and radical groups from the FBI and on some occasions from the CIA. A member of my staff would review the material to determine if it should be forwarded to Mr. Haldeman, that is, for bringing to the President's attention, or sent to another member of the staff who might have an interest in the contents of the report. Mr. Chairman, from time to time I'm going to skip parts of the statement in an effort to make sure that I can move as quickly as possible and get the statement completed within the time the committee has requested. So I will...
I believe it'd be well to read the whole statement since you thought it was important enough to write it.
I'll honor the chairman's wish. For example, Len Garment would be sent information regarding Indian uprisings. Mr. Kissinger or General Haig, information regarding travels of anti-war groups to Hanoi. Also, prior to and during a demonstration, my office would prepare summary reports for the President of the anticipated size of the demonstration, any information about the leaders of the demonstration, and during the demonstration, a description of the activities of the demonstrators and the government's handling or anticipated handling of the demonstration. Contrary to the policy that existed before I came to the White House, I sought to keep the White House out of these tactical decisions regarding the demonstrations. I felt these were decisions for the Department of Justice and the police. I felt my job was to merely keep the White House informed as to what might happen or was happening. My own desires in this matter were sometimes superseded when Mr. Ehrlichman or Mr. Haldeman did not like the way a particular demonstration was being handled. Sometimes they so instructed me to inform the Justice Department or Chief Wilson of the Metropolitan Police, and sometimes Mr. Ehrlichman himself would so inform the Justice Department or Chief Wilson. As soon as a potential demonstration was in the wind, I began receiving calls from Mr. Larry Higbee, Mr. Haldeman's principal staff assistant, requesting intelligence reports. I also received frequent complaints regarding the quality of the available information, despite the fact that I felt the White House had the best information available to the government. I became directly and personally aware of the President's own interest in my reports regarding demonstrations when he called me during a demonstration of the Vietnam Veterans Against the War, which occurred on the mall in front of the Capitol. This was the occasion in May 1971, and I believe that's the date, when the government first sought to enjoin the demonstration and later backed down. The President called me for a first-hand report during the demonstration and expressed his concern that I keep him abreast of what was occurring. Accordingly, we prepared hourly status reports and sent them to the President. I was made aware of the President's strong feelings about even the smallest of demonstrations during the late winter of 1971, when the President happened to look out the window of the residence of the White House and saw a lone man with a large 10-foot sign stretched out in front of Lafayette Park. Mr. Higbee called me to his office to tell me that the President's displeasure with the sign in the park, and told me that Mr. Haldeman had said that the sign had to come down. When I came out of Mr. Higbee's office, I ran into Dwight Chapin, who said he was going to get some thugs to remove the man from Lafayette Park. He said it would take him a few hours to get them, but they could do the job. I told him I didn't believe that was necessary, and
The audience are held by the consent of the committee, and I'm going to request the audience to refrain from giving expression of their feelings by laughter or otherwise. And I hope the audience will restrain themselves in that respect.
I told him I didn't believe that was necessary. I then called the Secret Service and met with Mr. Lewis Sims. Mr. Sims said that he felt that the park police could work it out. I went out with Mr. Sims, surveyed the situation, and Mr. Sims talked with the park police. Within 30 minutes, the man had been convinced that he should move to the back of Lafayette Park. There, the sign was out of sight of the White House. I reported back to Mr. Haldeman, and after a personal look-see, he was delighted. I told Mr. Chapin to call the troops off. I also recalled the first time I ever traveled with the President was on a trip in 1971 to the Football Hall of Fame and on to Iowa to open a dam. After arriving at the Akron-Canton Airport, I noticed there was virtually no hostile demonstrator in sight of the President. Later, when the President arrived at the motel he was spending the night in Akron, I was a few paces behind him as he walked into the lobby. Across the street were chanting Viet Cong flag-waving demonstrators. The President, after seeing the demonstrators, told the Secret Service agent beside him, in some rather blunt synonyms, to get the demonstrators out of there. The word was passed, but the demonstrators could not be moved, much to the distress of the advance men who were responsible for the president's trip. It was after observing that incident that I talked with several individuals in charge of advancing presidential visits, and that I learned a major part of any presidential trip advance operation was ensuring that demonstrators were unseen and unheard by the president. In early February of 1972, I learned that any means, legal or illegal, were authorized by Mr. Haldeman to deal with demonstrators when the president was traveling or appearing someplace. I would like to add that when I learned of the illegal means that were being employed, I advised that such tactics not be employed in the future, and if demonstrations occurred, they occurred. I stated earlier that there was a continuing dissatisfaction with the available intelligence reports. The most frequent critic was Mr. Haldeman, but the president himself discussed this with me in early March of this year as a part of the planned counteroffensive for dealing with the Senate Watergate investigation. The president wanted to show that his opponents had employed demonstrators against him during his re-election campaign. However, with each demonstration that the president was confronted with and each incident that occurred during the campaign, my office had sought to determine if it had in fact been instigated by political opponents of the president, Senator McGovern, the Democratic Party, or whomever. We never found a scintilla of viable evidence indicating that these demonstrators were part of a master plan, nor that they were funded by Democratic political funds, nor that they had any direct connection with the McGovern campaign. This was explained to Mr. Haldeman, but the president believed that the opposite was, in fact, true. I have submitted to the committee, Exhibit Number 1, the text of the president's memorandum to me on this subject. On February 16, 1973, almost a month prior to this direct request from the president, I had, at Mr. Haldeman's request, received all the available intelligence on the demonstrations the president had been subjected to during the 1972 campaign. This intelligence did not evidence what the president was looking for, but I turned it over to Mr. William Baruti, telling him that the president wanted a speech as part of a counteroffensive to the Watergate inquiry. Several weeks later, Mr. Baruti reported that he too agreed that the information wasn't there for such a speech. While there were other things which occurred that evidenced the concern about demonstrators, I believe that the foregoing gives this committee a good sampling of the degree of concern. The committee has asked me about concern over leaks. I believe that most anyone who worked at the White House during the past 4 years can attest to the concern that prevailed regarding leaks, any and all leaks. This was a matter of frequent discussion among staff members, and in some instances, leaks were investigated by Mr. Haldeman's office or Mr. Ehrlichman. I have submitted to the committee, Exhibit Number 2, some documents evidencing the types of investigations that were made. I began to understand the high degree of concern after I got to know Mr. Jack Caulfield, who'd been assigned to my staff. I would guess that I'd been at the White House almost a year before Mr. Caulfield told me that he had been directed by Mr. Ehrlichman to wiretap a newsman's telephone in pursuit of a leak. Mr. Caulfield told me that the wiretap was on for only a short period of time because he believed that the FBI had subsequently taken over. He told me that he had been directed to perform the wiretap when Mr. Hoover was unwilling, but Mr. Ehrlichman wished to proceed. The wiretap was undertaken, as I recall, in late 1969 or early 1970. Caulfield told me it was performed by Mr. Ulasewicz, Mr. John Reagan, and himself. He later repeated the story to me, telling me that it had been a rather harrowing experience when he was holding a ladder in a back alley of Georgetown while also trying to keep a lookout as another member of the group was working on the top of the ladder. He also told me that he'd received what he referred to as the pair numbers from Mr. John Davies, who was then on the White House staff and who had previously been employed or associated with the telephone company before joining the White House staff. I do not know what information, if any, they obtained, nor do I know any other details other than what I have related above. I have no idea if the reason for the wiretap was related to national security, but I believe that Mr. Caulfield told me that it was indeed Mr. Joseph Kraft's telephone that was tapped. While there was always a present concern about leaks, that concern took a quantum jump when the New York Times began publishing the Pentagon Papers in June of 1971. After the initial legal skirmishes to enjoin publication of the papers had died down, the White House concern about the problem of leaks had heightened. To the best of my recollection, and I've been unable to confirm this through White House records, it was in late June or early July that Jack Caulfield came to me to tell me that Mr. Colson had called him in at Ehrlichman's direction and instructed him to burglarize the Brookings Institution in an effort to determine if they had certain leaked documents. What prompted Mr. Caulfield to come to me was that he thought the matter was most unwise and that his instructions from Mr. Colson were insane. He informed me that Mr. Ulasewicz had cased the Brookings Institute and that Mr. Ulasewicz had made a friendly contact with one of the security men in the building, but that the security system at the Brookings building was extremely tight and would be very difficult to break in. Caulfield told me that he had so informed Colson, but that Colson had instructed him to pursue the matter, and if necessary, he should plant a firebomb in the building and retrieve the documents during the commotion that would ensue. Caulfield said that Colson's entire argument for burglarizing the Brookings was based on a publication he had obtained indicating that the Brookings was planning for the fall of 1971 a study of Vietnam based on documents of a current nature, and the fact that a consultant who had formerly been with the National Security Council worked there. Caulfield convinced me that Colson was intent on proceeding by one means or another, so I advised Caulfield that he should do nothing further and that I would immediately fly to California and tell Ehrlichman that this entire thing was insane. I flew to California on a military aircraft courier flight that was going to San Clemente. I sat with Mr. Robert Mardian on the flight, who told me he was also going to see the President about a highly important matter that he could not discuss with me, a matter which I will refer to later. When I arrived in California, I arranged to see Ehrlichman and told him that the burglary of the Brookings Institute was insane and to persuade him, probably impossible. He said okay, and he called Mr. Colson to call it off, and I called Mr. Caulfield to tell him it was called off. It was not until almost a year or more later that I learned the reason for Mr. Mardian's trip to see the President. Mr. Mardian later told me in a social conversation that he'd gone to see the President to get instructions regarding the disposition of wiretap logs that related to newsmen and White House staffers who were suspected of leaking. These logs had been in the possession of Mr. William Sullivan, an assistant director of the FBI, and were, per Mr. Mardian's instructions from the President, given to Mr. Ehrlichman. I had occasion to raise this question about these logs with Ehrlichman during the fall of 1972. I did not tell him that I had been told by Mardian that he had them. About February, let me go back here. After I had told Mr. Ehrlichman, or asked the question about the logs, he had flatly denied to me that he had the logs at that time. And it was about February 22nd or 23rd of this year when Time magazine notified the White House it was going to print a story that the White House had undertaken wiretaps of newsmen and White House staffers, and a request was being asked for that I further got into the matter. The White House press office notified me of this inquiry. I called Mr. Mark Felt at the FBI to ask him first what the facts were, and secondly, how such a story could leak. Mr. Felt told me that it was true, that Mr. Sullivan knew all the facts, and that he had no idea how it had leaked. I then called Mr. Sullivan and requested that he drop by my office, which he did. He explained that after much haggling, the wiretaps were installed, but as I recall, Mr. Sullivan said they did not have the blessings of the director. Mr. Sullivan explained to me all but one set of the logs had been destroyed, and all the internal FBI records relating to the wiretaps except one set have been destroyed, and all the material have been delivered to Mr. Mardian. After Mr. Sullivan departed, I called Mr. Mitchell, who told me he also had had an inquiry from Time magazine and denied to Time magazine any knowledge of the matter. I did not press him further as to what he did know. I then called Mr. Ehrlichman and told him about the forthcoming story in Time magazine. I told him of my conversations with Felt, Sullivan, and Mitchell. I also told him I knew he had the logs because Mr. Mardian had told me. This time he admitted they were in his safe. I asked him how Mr. Ziegler should handle it. He said Mr. Ziegler should flatly deny it, period. I thanked him, I called Mr. Ziegler, and so advised him. Turning now to the so-called plumbers unit that was created to deal with leaks. I first heard of the plumbers unit in late July of 1971. I do not recall ever being actually advised in advance that such a unit was being created in the White House, but I stumbled into it unknowingly when Mr. Eagle Krogh happened to mention it to me. I was not involved in its establishment. I only know that Mr. Krogh and Mr. David Young were running it under Mr. Ehrlichman's direction. Shortly after Mr. Krogh told me about his unit, he told me that they were operating out of a super secure location in the basement of the executive office building. He invited me down to see the unit, which I did, and he showed me the sensor system and the scrambler phone. I never discussed with Mr. Krogh or Mr. Young what they were doing or how they were doing it. It was through Jack Caulfield that I learned that Mr. Gordon Liddy was working with Mr. Krogh. I did not know Liddy personally, although I may have met him. All I knew about Mr. Liddy was that what Mr. Caulfield had told me, and was to the effect that Mr. Gene Recedes of the Treasury Department and Mr. Liddy had had a falling out, and Krogh had waded into the middle of the dispute by hiring Liddy and bringing him into the White House. I did not realize that Mr. Howard Hunt worked most of the time while he was at the White House in the plumbers unit until after June 17th of 1972. I had seen Hunt on many occasions in Colson's office and finally asked Mr. Colson who he was. He told me he was doing some consultant work for him and then introduced me. That was the only time I've ever talked with Mr. Hunt. I am not aware of what success the plumbers unit had in its dealing with leaks. I recall on one occasion, after Jack Anderson had printed the documents from a National Security Council meeting, asking Bud Krogh if they'd figured out who'd leaked the information to Mr. Anderson. He told me yes, but he couldn't disclose the name of the individual. As I have indicated, the June 1971 publication of the Pentagon's papers caused general consternation at the White House over the leak problem. On June 29, 1971, the President brought the subject of leaks up in a cabinet meeting as part of a White House orchestrated effort to curtail all leaks. As a part of that effort, Mr. Haldeman instructed Mr. Fred Malek, Mr. Larry Higbee, Gordon Strawn, and myself to develop a follow-up strategy for dealing with leaks. Malek and I never took the project very seriously, but Strawn and Higbee continued to push. I have submitted to the committee Exhibit Number 3, Memorandum outlining the project that finally developed, in which Mr. Malek was to take charge and Mr. Haldeman was to be brought in as the Lord High Executioner when a leak was uncovered. The committee will note from the documents which I have submitted that the project was to complement and not complete with the plumbers unit. To the best of my knowledge, this project never uncovered the source of a single leak. I shall turn now, pursuant to the committee's request, from leaks to the matter of political intelligence, with the hope that my voice will hold up through this entire statement. The pre-election White House thrived on political gossip and political intelligence. I knew of the type of information they sought even before I joined the White House staff. During the summer of 1969, while I was working at the Justice Department, the then Deputy Attorney General, Richard Kleindienst, called me into his office and told me that the White House wanted some very important information. Mr. Kleindienst instructed me to call Mr. DeLoach, then Deputy Director of the FBI, and to obtain from him information regarding the foreign travels of Mary Jo Kopechne. I was told that Mr. DeLoach would be expecting a call from me, and once I had the information in hand, I was to give it to Jack Caulfield at the White House. The incident stuck in my mind because it was of the rather sensitive nature of the information being obtained from the FBI and the fact that I was made a courier of the information. To this day, I can only speculate that I was asked to convey the information so that others could deny they had done so should the matter become known. It was not until I joined the White House staff and Caulfield was placed on my staff that I learned that Caulfield was assigned to develop political intelligence on Senator Edward Kennedy. Mr. Caulfield told me that within some 6 hours of the accident at Chappaquiddick on July 18, 1969, he had a friend named Tony on the scene who remained on the scene conducting a private investigation of the matter and reporting pertinent information back to him. It was not until this spring that I knew or could remember Tony's full name, Anthony Ulasewicz. Caulfield told me that Mr. Ulasewicz posed as a newspaper reporter and always asked the most embarrassing questions at any press gatherings relating to the Chappaquiddick incident. Caulfield also informed me that his instructions were to continue surveillance on Senator Kennedy, and he was doing so on a selective basis. I was told by Caulfield that although he had been assigned to my staff, that he would continue to perform various intelligence gathering functions assigned to him by Mr. Ehrlichman and Mr. Haldeman. I only recall once becoming involved in Mr. Caulfield's activities related to Senator Kennedy. That occurred in the fall of 1971 when I received a call from Larry Higbee, who later, and I should say later these calls were followed up by Mr. Strawn, who told me that Haldeman wanted 24-hour surveillance of Senator Kennedy and regular reports on his activities. I passed this on to Caulfield and we discussed it. He told me that he thought that this was most unwise because it would require several men and could also uncover his activities in that Senator Kennedy was bound to realize he was under surveillance, and given the fact that it could be easily misinterpreted as someone who was planning an attack on his life, and that the police or the FBI might be called in to investigate. I agreed fully with Caulfield, and after some initial resistance, I convinced Higbee that it was a bad idea to have the day-in, day-out surveillance concept, and it was called off. Instead, Caulfield was to keep a general overview of Senator Kennedy's activity and pursue special investigations of activities that might be of interest. Caulfield seldom informed me of his findings, but occasionally he would bring matters to my attention. For example, Caulfield was instructed to investigate Senator Kennedy's visit to Honolulu in August of 1971. I have submitted to the committee, Exhibit Number 4, a copy of his report, which he passed on to me to see, along with several follow-up memorandum relating to the visit. Political intelligence often came from unexpected sources. For example, during this last spring of 1972, a top man at the Secret Service brought me information regarding Senator McGovern. I asked Mr. Colson if he were interested. He was very interested and had the information published. The persons on the White House staff who were most interested in political intelligence were Ehrlichman, Haldeman, and Colson. As the re-election campaign drew closer, I would have to say that it was principally Colson and sometimes Haldeman who sought information from my office that had political implications to it. While I've been unable to make a complete review of my office files to document the many types of inquiries, I do have some documents that evidence a fair sampling of the types of requests that were frequently made of me and how they were handled by my office. The documents are extremely sensitive and could be injurious to innocent people whose names are mentioned in them. Accordingly, I have submitted them for the committee's use, Exhibit Number 5, and I'm prepared to answer any questions the committee may have regarding these documents. In addition to the rather wide-ranging types of inquiries evidenced by the documents I have just referred to, in addition to the extensive efforts to obtain politically embarrassing information on Senator Kennedy, there were also frequent efforts to obtain politically embarrassing information on Mr. Lawrence O'Brien, the Democratic National Committee Chairman, Senator Muskie, and Senator McGovern. While the involvement of my office in seeking such information was peripheral, I have submitted to the committee, Exhibits Number 6, 7, and 8, records and documents which show the efforts of the White House to politically embarrass these individuals. Again, because of the very sensitive nature of the information contained in these documents and the problems that the information might unfairly cause those individuals, I shall not discuss the documents further, other than to point out to the committee that the interest in Mr. Larry O'Brien dates back, from my records, to the time I first joined the White House staff in July of 1970, while the interest in Senators Muskie and McGovern developed as the re-election campaign developed. I would now like to turn to a political intelligence and security plan that was designed for the campaign but ultimately rejected. While Caulfield was a member of my staff, the use of Mr. Ulasewicz slowly diminished, in that I had no need for such investigative work and only requested Caulfield to obtain investigative information when someone else on the staff requested it. While I did try to find assignments for Caulfield that related to the work of the counsel's office, it was difficult in that he was not a lawyer. Mr. Caulfield was aware of the situation, and in the spring of 1971, he came to me and told me he was thinking of leaving the White House staff to establish an investigative security consulting corporation. He felt that there was a need and a market for such an activity, and what he described as a Republican Intertel. The Intertel firm being a long-established firm that's been in existence for a number of years working in the field. He told me that he felt that he should get started as soon as possible so that he could have a going concern by campaign time, and that his firm could provide investigative security assistance to the campaign. We casually discussed this on several occasions. The basic and initial concept he had developed was an operation that could be funded by contracts with corporations. Mr. Caulfield's firm would provide services for these corporations, but would also provide free services to the 1972 re-election campaign. I recall telling Caulfield that I could not help him in the intelligence field because I did not have any expertise in the area, but I advised him that he should work with a lawyer in developing the concept he had just outlined to me, because it was fraught with legal problems. For example, I told him that corporations are prohibited under federal law from making direct or indirect campaign contributions. Shortly after these conversations, Caulfield informed me that he had formed a group to develop a plan to submit to Mr. Ehrlichman, Mr. Haldeman, and Mr. Mitchell. The planning group intended to become the principal officers of the corporation once it commenced its activity. Caulfield and the group spent several months developing their plans, and in early August or September of 1971, Caulfield brought me a memorandum entitled Operation Sandwedge, and told me that he was seeking a meeting with Mr. Ehrlichman to discuss the matter and requested that I assist him in getting a meeting with Mr. Mitchell. I do not know if Mr. Caulfield met with Mr. Ehrlichman. If he did, I was not present and have no knowledge of the meeting. I read the memorandum and found it to be a privately operated extension of the types of things that Caulfield had been performing for Mr. Ehrlichman. I returned the memorandum to Caulfield and told him I would raise it with Mitchell. To the best of my recollection, Operation Sandwich envisioned the creation of a corporation called Security Consulting Group, Incorporated, which was to have offices in Washington, Chicago, and New York. It was to have an overt and a covert capacity. The covert capacity would have operated out of New York, presumably under the aegis of Mr. Ulasewicz. It was to be separate and apart from the other operations in Washington and Chicago. The principal activity of the Security Consulting Group was to provide private security for all phases of the campaign, but the New York covert operation would have the capacity to provide bagged men to carry money and engage in electronic surveillance if called upon to do so. Although I returned the copy of the Operation Sandwich memorandum given to me by Mr. Caulfield, I did find in my records a copy of a proposed budget, which reflects some of the items I've just mentioned. I also found a number of memorandum relating to the campaign security aspects of the plan. I have submitted these documents to the committee, exhibit number 9. I did discuss Operation Sandwedge with Mr. Mitchell. I recall that he was not interested at all. He told me that he thought that Jack Caulfield was a fine person, but he felt that the principal problems would relate to security and the problems that demonstrators might cause to the campaign. Mr. Mitchell said he wanted a lawyer to handle any such operation and asked me to think about candidates. I told him that Jack Caulfield had requested an opportunity to discuss his plan with him. I told him that I told Jack I would convey the message. Mitchell did not wish to discuss the proposal, so I kept putting Caulfield off, and when he raised it with me, because I liked Jack, I did not want to hurt his feelings, I continued to keep putting him off. I also recall that Ehrlichman raised Operation Sandwich with me. I do not know if this was a result of his meeting with Caulfield or Caulfield sending him a copy of the memorandum. Ehrlichman told me that he would like to keep Tony Ulasewicz around during the campaign, but he did not think much of Mr. Caulfield's proposed grand plan. Ehrlichman told me that Mitchell knew about Tony Ulasewicz and that Mitchell and Jack Caulfield should talk about Tony's future. Meanwhile, Caulfield kept requesting an answer on his plans. He had his heart set on the proposal. He had spent long hours preparing it, and I knew he was going to be very disappointed to learn that it had been shot down. Every few weeks, Mr. Caulfield would send me an item or two to prompt my attention and to prompt me to take action. I have submitted to the committee, in Exhibit number 9, the types of items he would send. I would just file them and do nothing, as I decided that the best course of action to save Jack's feelings was to let the matter die a natural death through no action. Indeed, that happened. By November 1971, Mr. Caulfield realized that his plan was dead, and he abandoned the idea. Realizing this, he told me he would like to work for Mr. Mitchell during the campaign as an aide-de-camp and requested that I assist him in getting an appointment with Mr. Mitchell. I arranged for him to meet Mr. Mitchell on November 24, 1971. Pursuant to Mr. Caulfield's request, I was not present during the entire meeting, but Jack later said that Mr. Mitchell had requested that he do some investigative work on the McCloskey campaign. Apparently, Caulfield convinced Mr. Mitchell that some greatly reduced version of Operation Sandwich might be of value, or he was seeking to show Mitchell what he could do. At any rate, Caulfield continued to call his intelligence gathering operation Operation Sandwich. I have submitted to the committee, Exhibit number 10, copies of the investigative report Mr. Caulfield prepared for Mr. Mitchell on the McCloskey, New Hampshire campaign, and I hasten to add that, to the best of my knowledge, Caulfield employed no illegal procedures in gathering this information. Pursuant to the request of Ehrlichman that Mitchell determine whether continued funding should be provided for Mr. Ulasewicz, Mitchell asked me what Ulasewicz had been doing. I told him I did not know, but I would have Caulfield prepare a summary of the activities. On January 12, 1972, I informed Mitchell that Caulfield had prepared such a list and suggested he meet with him. I refer the committee to Exhibit number 11. I would also note at this point that there is no list accompanying that exhibit because while I initially thought I did have a list, I have searched my records that are available and I have no such list other than the possibility there might be a list in my files that remain at the White House. I do not recall how this matter was resolved, but I believe some arrangement was made to compensate Mr. Ulasewicz, but to my knowledge, he was not used in any manner other than that to which I shall refer later in my statement. Mr. Caulfield and Mr. Kalmbach would know about the arrangements that had been made. I shall now turn to my knowledge of how an intelligence unit was established at the Re-Election Committee. To the best of my recollection, it was the spring of 1971 that Mr. Haldeman discussed with me what my office should do during the forthcoming campaign year. He told me that we should take maximum advantage of the president's incumbency, and the focus of everyone in the White House should be on re-electing the president. It was decided that the principal area of concern for my office should be keeping the White House in compliance with the election laws and improving our intelligence regarding demonstrations. I was also told that I should provide legal assistance in establishing the Re-Election Committee and ensuring that they had their own capacity to deal with the potential threats of demonstrations during the campaign, and particularly the convention. I advised Haldeman that Jack Caulfield was developing a security plan and that he wanted to discuss his plan with Mr. Mitchell and Mr. Ehrlichman. I also told him I would seek to get the Interagency Evaluation Committee working on the potential for demonstrations during the campaign and subsequently called Mr. Bernie Wells, the head of the IEC, to my office and told him of the concern of the White House for good intelligence during the coming campaign. During the months that followed, I devoted most of my time to regular office functions, keeping abreast of the new campaign legislation and familiarizing myself with existing election laws, the Hatch Act, and related laws. It was not until after the proposed Operation Sandwich had been shelved and Magruder had left the White House to form the re-election committee that I began receiving calls from Strawn and Magruder that I was expected to suggest a lawyer to head up the demonstration intelligence operation at the re-election committee and to serve also as general counsel. On several occasions, Magruder told me that he would like to have Mr. Fred Fielding, my principal assistant, for this job. Fielding and I discussed it, but rejected it for several reasons. First, Fielding was aware of the fact that I was considering leaving the White House at that time. I was actually interviewing for jobs outside the government, and he knew that I would recommend that he succeed me as counsel. Secondly, if I stayed, I would need his assistance during the coming months. I might add, parenthetically, as I look back, if I had accepted the job I was interviewing for at that time, I would not be sitting here today. After I informed Magruder that Mr. Fielding was not available, he requested I suggest someone else because he was desperately in need of an in-house lawyer. Accordingly, I next went to Mr. Krogh and asked him if David Young might be available and interested. Krogh told me that Young was very much involved in the declassification project and could not be spared. The reason Young had occurred to me is that I had spent several days traveling with him in mid-October, interviewing prospective candidates for nomination to the Supreme Court. I might add that during those days of traveling around the country together, he never told me what the plumbers unit was doing or had done. But I felt that Mr. Young was a bright and extremely capable lawyer who would make an excellent general counsel and could handle the security and demonstration problems of the campaign. During my conversation with Mr. Krogh about Young, he suggested Mr. Gordon Liddy might be available, in that he had just about completed his work. Krogh spoke very highly of Liddy's legal ability and said that his FBI Treasury Department background in law enforcement would qualify him to handle a demonstration intelligence and security operation for the re-election committee. I did not know Mr. Liddy, but I respected Krogh's judgment, both as to his judgment of other lawyers and his knowledge of law enforcement. Bud had dealt with the demonstration problem for the White House before I joined the staff. I asked Mr. Krogh to find out if Mr. Liddy was interested. Several days later, Krogh informed me that Liddy was interested and asked me to come to his office, Krogh's office, and meet Liddy and describe the job. I did this. I told Liddy that the primary responsibility for the job was to serve as the lawyer for the re-election committee, but among the responsibilities, the general counsel would be keeping abreast of the potential of demonstrations that might affect the campaign. Liddy said he was interested. Krogh said that he would first have to clear this with Ehrlichman. I advised them that Mr. Mitchell and Mr. Magruder would be making the decisions on filling the post, and if Krogh got the okay from Ehrlichman, I would set up a meeting for Liddy to be interviewed by Mr. Mitchell. When Mr. Krogh gave me the okay from Ehrlichman, I called Mr. Mitchell, and I told him that Krogh, with Ehrlichman's approval, had suggested Gordon Liddy for the general counsel post. And I arranged for Liddy to meet Mitchell on November 24th, 1971, after Mr. Caulfield met with Mr. Mitchell. I attended the meeting with Mitchell and Liddy, and I have submitted to the committee, exhibit number 12, a copy of an agenda Mr. Liddy prepared for the interview session. While I cannot recall every detail that was discussed, I do recall that it was a very general job-type interview. Mitchell realized that Liddy was not familiar with the election laws and asked if I would assist him in any way I could in getting himself familiar with those laws. I agreed. There was virtually no discussion of intelligence plans other than that Liddy would draw up some sort of plans. Most of the conversation centered around title and compensation. Mr. Mitchell agreed that Liddy would be titled general counsel. I do not recall the rate of his compensation. I also recall that Liddy asked Mr. Mitchell when he would actually join the campaign, but Mitchell said he did not know. After this meeting, Mitchell called me to say that he wanted Magruder to interview Liddy because Magruder would be the man working most with him. I so advised Liddy, and on December 8, 1971, Magruder requested I bring Liddy over to his office for an interview. The interview in Magruder's office on December 8th was brief and non-substantive. Magruder told Liddy that he had a host of legal problems that needed attention immediately and pointed to a stack of papers that I assumed contained the problems that he was concerned about. There was a brief discussion of Liddy's responsibilities for demonstrations vis-a-vis the campaign, and Liddy said that after he got acclimated to the committee's problems and needs, he would draw up a plan. Magruder requested that Liddy come to work as soon as possible, which I believe was the following Monday. After Liddy was hired at the re-election committee, I informed my staff, principally Mr. Fred Field and Mr. David Wilson, that they should assist Liddy in becoming familiar with the election laws. I made my election law file available to Liddy and believed that he used them, and he had periodic contact with my staff and myself on election law matters. I can recall that I had several discussions with Liddy about his responsibilities with the committee, the re-election committee, in complying with the election laws. He told me that he had more work than there were hours in the day to complete it. I urged him to get volunteer lawyers to assist him and suggested several names of lawyers who might assist him. I can also recall that several weeks after Liddy left the White House, he was asked to turn in his White House pass. Liddy came to me and asked me to intervene in his behalf so he might retain his pass and avoid the cumbersome procedures of clearance every time that he wished to enter the White House. I thought that my office would have a good deal of contact with Liddy, so I requested that he permitted to keep his pass. This request was turned down, however, because they had decided to provide a fixed number of passes for people at the re-election committee, and Magruder would decide who got the passes. I so informed Liddy and never heard any more about the matter. The next time I recall meeting Mr. Liddy, I might insert before this that I did have a brief occasion to see him in early January, I believe about the 9th through the 14th or 15th, when he attended a general conference in San Diego on the entire scope of the convention and the security problems that were going to confront the convention in San Diego. It was after that, the next time I recall meeting Liddy was at a meeting in Mitchell's office in January 27 of 1972. Magruder called my office to set up the meeting, and only after I called Magruder to ask why he wanted me to attend the meeting did I learn that Liddy was going to present his intelligence plan. I met Magruder and Liddy at Mitchell's office. Liddy had a series of charts or diagrams which he placed on an easel, and the presentation by Liddy began. I did not fully understand everything Mr. Liddy was recommending at that time because some of the concepts were mind-boggling and the charts were in code names, but I shall attempt to reconstruct the high points that I remember as best I can. Liddy was, in effect, making a sales pitch. He said that the operation he had developed would be totally removed from the campaign and carried out by professionals. Plans called for mugging squads, kidnapping teams, prostitutes to compromise the opposition, and electronic surveillance. He explained that the mugging squad could, for example, rough up demonstrators that were causing problems. The kidnapping teams could remove demonstration leaders and take them below the Mexican border and thereby diminish their ability, the ability of the demonstrators to cause problems at the San Diego convention. The prostitutes could be used at the Democratic convention to get information as well as compromise persons involved. I recall Liddy saying that the girls would be high class and the best in the business. When discussing the electronic surveillance, he said that he had consulted with one of the best authorities in the country, and his plan envisioned far more than bugging and tapping of telephones. He said that under his plan, communications between ground facilities and aircraft could also be intercepted. I might also add at this point, he also gave an elaborate description of intercepting various